Hello students, here is Ashu Gupta, Assistant Professor. Again welcomes you all on the behalf of the Inpress Law College. In today's lecture, we are going to cover about the provision relating to the arrear and the recovery penalties in terms of the UP Revenue Code 2006. There is some provisions given under section 171 in terms of the arrears and the recovery or the punishment in relating to the land revenue, in relating to the collection of the land revenue. Section 171 says that if any person committing default in payment of an arrear of land may be arrested and detained in custody in the Tehsil lockup, and if there is no such lockup at such other place as may be prescribed for a period not exceeding 15 days unless the arrears are sooner paid. If we talk about the next section, that is 172, provisioned about the attachment and the sale of movable property in case of any balanced arrear or the recovery procedure. The SDO may attach and sell movable properties of the defaulter, including agriculture produce, given under section 172. 173 also provisioned about the attachment of bank account and locker of the defaulter, according to which the attachment of any bank account of the defaulter shall be made by serving a garnishee order on the manager in charge of the branch of bank concerned in the manner laid down in Rules 46 of Order 21 contained in the first schedule of the CPC, and in case of locker hired by the defaulter, the same shall be sealed in the presence of such manager, who shall await further orders of the SDO regarding the preparation of inventory of its contents and their ultimate disposal. There is also a provision relating to the attachment of the holdings, wherein the section 174 provision that the collector may attach any land in respect of which any arrears of land revenue is due. If the amount of arrears is not paid within a period of 30 days from the date of such attachment, the collector may proceed in accordance with the provisions of section 175 or 176. If we talk about the section 175, says and provision about the lease of holding, according to which where any land is attached under section 174, the collector may, not withstanding anything contained in this code, but subject to such conditions as may be prescribed, let out the same for such period not exceeding 10 years, as he deems fit to any person other than the defaulter. The person to whom any land is let out shall be bound to pay the whole of the arrears due in respect of such land and to pay the land revenue during the period of lease at the rate payable by the defaulter in respect of such land immediately preceding its attachment. If during the period of lease the lessee commits defaulter in payment of any amount due under the lease and no other person is to take the land on lease for the remaining period, then such amount may be recovered from such lessee by anyone or more of the processes mentioned in section 170, and the lease shall be liable to determine. But upon the expiry of the period of lease, the land shall be restored to the tenure holder concerned, free of any claim on the part of the state government for any area of revenue in respect of such land. And there is also a provision given under section 176 relating to the sale of the holding in case of that type of area or the recovery, where a suitable person is not forthcoming to take on lease the land attached under section 174, or where the lease of such land is determined under section 175, the collector may sell the whole or any part of such land in such manner as may be prescribed and appropriate the sale proceeds in accordance with section 200. And the collector shall report to the revenue board every sale of land under subsection 1 of section 176. Now, section 177 provision about the attachment and the sale of the other immovable property. If the collector may realize any arrears of land revenue by the attachment and sale of interest of a defaulter in any other immovable property belonging to such defaulter, provided that the house or other building and land immediately appurtenant belonging to an agriculturalist and occupied by him shall be exempted from attachment under this section. And after that, there is a provision relating to the appointment of the receiver. The appointment of the receiver we'll discuss later on in the next lecture. Hope you will enumerated it into your study very well. Thank you very much.